Okay, we're on the record with case D145009110D, Jensen versus Jensen. Appearances, please.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157. I'm present and appearing for the plaintiff, Caroline Jensen.
Thank you.
Bruce Shapiro, Your Honor, bar number 4050 for the plaintiff, Shane Jensen, who I believe is on the video feed.
I believe I have both of the parties here on the record. I have spent hours, hours, reviewing this extensively. I have read probably more of this than what I needed to read. So I'm ready to make a decision right now, but do y'all have anything new to add?
Your Honor, if I may briefly just summarize our argument and legal and factual basis.
Go ahead.
If the court please. First and foremost, I don't see any demonstrated legal or factual basis for the defendant to receive any award of fees. He's clearly not the prevailing party by the according to the interim motion orders, as well as the final stipulated judgment that took 3.5 years to receive because he refused to pay child support and stipulated to a very sizely judgment for arrears. Moreover, I want the court, as the court knows, before granting fees, you have to identify the legal basis therefore. So the legal basis, first of all, if you look at the decree of divorce entered in September 19 of 14, there is a prevailing party clause, and that was not removed by the subsequent July of 2015 stipulation that says that Caroline should get her fees based on that. The other bases are clear. Chapter 18, EDCR 7.60, NRS 125.180, in addition to the older statutes, NRS 125B, and the newer chapters that took over pending this litigation that state you should include in your order an award of fees. So you have all of those legal bases, and in order to, to survive appellate review, those should be mentioned in your decision. Also, Your Honor, very clearly, and because we only had, this record was so long and we only had 30 pages to argue, I know the court is very well aware, this court, that under Wright v. Osborne, you must assess and consider the serious disparity in income of these parties in these custody and child support cases. That would be Wright v. Osborne, 114 Nevada at 1370. Also, you'll find a lot of that language and discussion on this overall issue of attorney's fees in the Miller v. Wilfong cases. And in your findings, Your Honor, you just have to state that, you're denying theirs because there's really no legal or factual basis. In reviewing the records, you've carefully reviewed our billing records that have all been attached and make a finding as to each Brunzell factor. I mean, clearly, these are reasonable and necessary fees. You also note, hopefully, I've done a very thorough review, because of Mr. Jensen, not being prevailing or otherwise, he had 54 hours of non-billable time. Now, I don't know, I didn't really categorize exactly what, but he got about $22,000 in free fees from his prior counsel with their firm. I don't know if it's because they bring 2 or 3 people to court and they don't overbill, but, they were very overzealous in pursuing the case. And clearly, in the July 8, 2015 stip and order at the first page, line 20, any provision not modified, you go back to the decree. So you have so many bases to grant this. I just want to ensure that, all of those and all the Brunzell factors are carefully analyzed, whether, and it looks like you're ready to rule from the bench, which will make my client quite excited to have a final order and judgment hopefully entered today in her favor, Your Honor. And if you have any further questions, Your Honor, I'd be glad to answer those.
Mr. Shapiro, would you like to respond?
Yes, Your Honor. Ms. Vaccarino is correct that the court, as far as we're concerned, the only issue here is really fees. And the court has to have a basis to find the fees. And there's been no finding that anyone filed a frivolous motion. As far as prevailing party, there is no prevailing party. Every issue has been resolved up to this point. So there's case law that if you stipulate to something, there's no prevailing party. As far as the disparity of incomes, you still have to have a basis. And Wright versus Osborne was a divorce case, not a post-judgment case. So the disparity of income of the parties, if that in fact exists, that's not relevant. So the Supreme Court has already found that there's no fees if there's legitimate and good faith disputes. Obviously, every issue was a legitimate and good faith dispute because the parties ultimately resolved it. So from our position, the only issues that the court should properly award fees on are the two issues that are before the court today. Does the court have the jurisdiction to award interest on non-existent constructive arrears? And two, does the court have the jurisdiction to award penalties, one, when the statute no longer exists, and two, if it did, it was to penalize a party who did not pay child support that was reduced to a judgment. Here, there was no judgment on child support. The court could see that Mr. Jensen made good faith and reasonable attempts to resolve the child support issue for years before the parties were finally able to agree to that judgment. So everything that happened in the past, there's just simply no basis for that because no party prevailed and there were good faith disputes. As far as the two disputes, we don't believe that there's any legal authority, nor has Ms. Vaccarino cited any authority that the court has jurisdiction to award interest and penalties on constructive arrears that were at dispute. So if the court's read the briefs, the court's familiar with what the issues are, the parties agree on what the issues are, they just disagree on how they should be resolved.
Your Honor, just briefly, Mr. Shapiro says there's some case that doesn't allow you to award fees when it took 3.5 years for him to finally pay a $32,000 judgment in arrears. So that's just nonsense. And Wright v. Osborne was cited in Miller v. Wilfong, which is a paternity case, not a divorce case, that, quote unquote, cited to Wright at 114 Nevada at 1370. So Miller v. Wilfong definitely is on point and says that you can grant fees even to non-married, just paternity cases. One other thing, Your Honor, let's not forget that all of these settlement letters that were already filed in the record in 2019 by the defendant, and us now for you to look at the alleged reasonableness of offers, the only way the defendant would have ever agreed to pay anything is if she would give him 50 more days per year, grant him joint custody, and then he said he would pay the increased amount. He finally stopped that when my client, relocated after she retired from the military with high honors. And it's been in the record very clearly that it was Shane Jensen who received a less than honorable discharge.
I don't think that has any bearing. So, we don't need to sit here and cut down somebody's history. I will not tolerate that.
I don't want to cut his history down.
That has no bearing on what's going on today.
Okay. Well, I will say is this, that his conduct in this case in avoiding finally ever paying the right amount, paying $1,300 less for 3 years, is less than honorable. And it doesn't have to be a frivolous case, Your Honor. All it has to be is that you look at these fees incurred. What was the final result? The final judgment, you cannot award prevailing fees. The case law is clear until final judgment. The fact that he settled, he wants to call himself a hero and tell her to eat $100,000 in fees to receive $32,000 in child support. He spent $103,000, which is 62 months of child support to avoid this. So he would rather have spent 6 years, 5 years in child support than just give it to his son and settle the case earlier. So, Your Honor, we only hope, it's unfortunate that this was handed to you to look at the entire record and make this call, but it's clearly a call where a majority or all of her reasonable and necessary attorney's fees and costs should be recovered. The red herring arguments they made about things that I allegedly did wrong, they tried to enter an order that did not include the exact minutes. And when I tried to have that stricken from the record or set aside, Judge Steele back then struck the notice of submission of the proper order as an exhibit by mistake, and that's where that red herring issue came up. So it's very clear the only basis they tried to say was that some kind of conduct, which isn't even right, that Judge Pomeranz dismissed when they made these arguments when she took the case over. There is no basis for them to receive fees, and I think I'm confident that you can clearly outline the factual legal bases and all of the Brunzell factors that I have met in seeking the fees and costs. I also have given her a $100 discount on my very reasonable rate that would have made this judgment requested be much larger, which can be considered under Brunzell. I thank you for the court's indulgence.
Okay. I'm going to go ahead and note the fact that I know that there was a prior order for attorney's fees and costs. It was determined when it comes to the disqualification proceedings. So nothing in this order has anything to do with any of the work that was put into that long, huge chunk of time that was in there. A stipulated decree of divorce was entered into this case on September 18, 2014, wherein the parties did agree to joint physical custody with no child support. On July the 8th, 2015, there was a stipulation and order that specifically stated on page 1, line 20 through 21, that, quote, any and all orders not modified by this stipulation and order shall remain enforceable orders. On page 6, from line 22 to 23, child support changed commencing August 15, 2015, to a lump sum payment of $3,600 each year, which equated to $300 a month. Line 25 through 26 shows this amount was a downward deviation due to the expected airfare expenditure by Shane. In contracts, even a negotiated stipulation and order that modifies terms of a parenting agreement, any ambiguity will go against the drafter. The July 8, 2015 modification, the parties did not modify the primary physical custody designation. Therefore, it was left as a joint physical custody relationship. The ambiguity in this case will remain giving Dad a good faith reason to decide to litigate that issue throughout that entire 3 years. Until custody changed, giving Mom primary physical custody, the principles of Wright v. Osborne applied. The parties agreed to this amount, so we have to assume this was fair since Mom was the party who had the attorney and the advantage. A schedule of arrearages was prepared that was taken care of early on. And I am not sure really what that was about. But there was a hearing on January 24, 2018, where a defendant was to prepare the order and failed to do so, creating the trial date to be vacated and January 24th order to be set aside by order on March 1st, 2018, which that was also later set aside. That order from July 25th still left custody being joint physical. Then plaintiff filed 2 motions on March 19, 2018. One was for reconsideration and restatement of the January 25th decision. The other was trying to take time from Dad, who had a right to fight this, trying to get more child support, This motion also stemmed from plaintiffs that was defendants not preparing the order for a proper reconsideration to be filed. I gotta check. No, sorry, that was plaintiff. I apologize for that. I was right. So the plaintiff was trying to do a motion for reconsideration on an order that was never put in place. The lack of preparing the order in a timely fashion created the situation for the filings of the the 2 March 19, 2018 motions, the 2 April 6, 2018 oppositions, the May 15, 2008 reply, and the May 18, 2018 reply, and a hearing on May 22, 2018. On April 18, 2018, Dad made the offer of $1,115 per month, retroactive to October 24th, 2017. And he offered to pay for transportation on all but a couple of exceptions. It would have taken that issue out of the negotiations, which seemed to have been a huge part of this. That $1,115 was based upon the caps that was there at that time. In November 2020, the parties entered into an agreement that covered everything except interest and penalties and attorney's fees and costs. I want to note that right now I just took a look at what the parties' incomes are. It's very close to even. Mom is earning $23,000 a month, and I believe, because I didn't write it down, sir, forgive me if I'm too wrong, Mr. Shapiro, please correct me. I believe his is at about $24,000 a month. And then he pays child support to her of over $1,000 a month.
That's her recent income, Your Honor. That changed only this year. Well, it was a drastic disparity from her prior FDFs that I can point out to you.
Well, let me finish with this.
Okay, Your Honor. Thank you.
The defendant is correct in that there is no order in the record regarding child support until the parties stipulated an order dated November 19th, 2020. Both parties briefed that defendant immediately paid the arrears that were agreed upon. I find that the motion and opposition that was filed October and November 2017 were based on good faith reasons. Where it went sideways and began costing, where it should not have, was after the January 25th, 2018 hearing, when plaintiff did not submit the order as she was ordered to do, not just once, but on 2 separate occasions. That order still has not been submitted to date. Therefore, I am awarding defendant $10,045 in attorney's fees for the drafting, the opposition, the replies, and the 2 hearings associated with the motions filed by the plaintiff attempting to straighten out the problems that she herself created. In making this determination, I took the Brunzell factors into consideration. We have to also look at Caratoni's work that they did over at Dickerson, because they did a lot of work into this case and trying to negotiate and the first round of stuff. They've had 13 years and 7 years of the two attorneys that was involved. Mr. Shapiro has practiced for over 30 years. He is a fine, upstanding attorney. Both law firms exhibited a great deal of professionalism in keeping this case moving towards settlement, as did you, Ms. Vaccarino. The attention to detail and keeping the eye on the ball was excellent. They expended more hours than charged, which that's appreciated by any person who's having to pay attorney's fees. The result, except Mom's moving, was about where the settlement offers were tendered almost from the very beginning. It's just been here recently that Mom decided to move to Missouri, and then it settled 100%. But for this area that was brought about by plaintiff's failure to prepare an order back January 2018, I would not be awarding any fees at all in this matter, because I believe that all the other issues was fair and accurate. Once again, I want to reiterate that there was no judgment prior to the decisions here in the stipulation and agreement that y'all recently filed. He immediately paid it, so there is no reason for judgment on any interest, any penalties, and right now statute does not even allow penalties any longer. If that one order had been done, this may have been a totally different conclusion, but it was not. It racked up a lot of attorney's fees and a lot of needless work on both sides. And people just need to start paying a little bit more attention to detail. And I appreciate your time. And Mr. Shapiro, would you please prepare the order?
I will,
Your Honor, I just want to be clear, because when you first made your findings, you said did you notice that I did a notice of submission of proposed order? The defendant was supposed to prepare the order, but I did try to submit it, and I don't know if you missed that. Before even 2018, I did a notice of submission of proposed order, and I did the motion for reconsideration the judge just struck it as an exhibit. Judge Steele used to strike those as they were exhibits, and I did the motion trying to explain that their proposed order did not include the fact that the child could fly unaccompanied, which was in the minutes. So I think that you missed that, which was the whole basis for you thinking that $10,000 shouldn't have been spent. So early on you said, wait, the plaintiff did file a motion to try and get it reconsidered, but it was the defendant that was supposed to prepare that order, didn't prepare it right, and I did a notice of submission that was in the record, and it should still be in the record because I filed it and attached it to the motion to get it reconsidered and get the case back on track. So I'm not sure what the basis is when they were supposed to do the order and we did it. And I don't know which order is still missing that you're referring to. The order that denied the motion to reconsider? I mean, so we did submit the order, exactly what the judge said. And she said until she found out and under Rivero counted up who had what time, she couldn't grant child support even though he was making enough under joint custody or primary to pay the max. I also would note, Your Honor, that their initial offer in April of 18 is contingent upon him getting 50 more days per year to be actually, in fact, under Rivero, which are supposed to take testimony. So if you're saying we should have waited to go to trial to have someone to count up the calendars, that doesn't seem appropriate. So I think that your basis to even grant the $10,000 is an error because we did try to submit the order from Judge Steele's first hearing, and where it got caught up is Shane's last attorney refused to include the accompanied minor. The father didn't want the child to fly unaccompanied, and Judge Steele disagreed and changed the prior order. And that was the big hang-up. And we did do due diligence.
And I did notice that I did have that wrong. It was the defendant that was supposed to have prepared it, and it did
so
not.
So we're getting the
$10,000
was
stricken. The second
so
time around. The second time around, when you did go in for the motion for reconsideration, you were ordered to prepare the order, and you did not. The judge said that you were to prepare and straighten it out.
Well,
that was
I don't understand.
The minutes that I read, and you know,
it's not. Your Honor, I still think that our motion. I'd have to look at. You're saying there's a January 25th hearing where we were supposed to prepare the order and we didn't, and that's why they're going to get $10,000. But we tried to submit the order. The whole debacle was the original order has never been entered, and then Judge Pomerantz changed everything when we went in before her and did do a temporary order. So with respect, Your Honor, I think that the factual, the record seems a little muddied on that, and I just want it to be clear because this is a long case. There's a lot of,
It has been a long case. And I actually believe that both parties were mule-headed in a lot of areas that you should not have been mule-headed.
Well, he wanted to be named joint physical, but he needed 50 more days.
And joint physical was something that was already in there, and he had an absolute right to fight it with everything that he could. It's an hour flight between here and where he was residing. So, it was a schedule that could have very easily have been and maintained joint physical, even under today's standards.
Under Rivero, Your Honor, you're supposed to count up what he exercised for the year prior. And he clearly in his letter stated he wanted 50 more days after she filed. And initially,
Ms. Vaccarino, you were the attorney who drafted that order. So any ambiguity is in there is going to go out against your client.
Well,
Mr.
Your Honor,
Jensen was not
living in...
Ms. Vaccarino, do not interrupt me. Mr. Jensen was not represented while you were doing those negotiations, and I'm not going to hold it against him when a seasoned attorney did not put things properly in the record. He had a right to fight it, and I'm going to recognize that right. He's not an attorney as you were and are. So, he had a right to fight joint physical custody. She's the one who moved to Virginia. Ma'am, don't interrupt me. She is the one who moved to Virginia No, he was. Which one moved to Virginia?
Yes, she moved to Virginia. He
Okay.
stayed in Nevada.
Okay.
While she was in Virginia, a few months later, he moved to Seattle.
It doesn't
She
matter.
came back to Nevada.
Okay, Ms. Vaccarino, that part does not matter. Your client
Why
was
not?
willing to maintain the joint physical relationship so long as she was able to move where she wanted to move. You may have purposefully left it out that it was going to change it, but I'm not going to hold that against Mr. Jensen because you also were the one who drafted the decree of divorce that gave them joint physical custody in the first place. You knew it needed to be changed if that was your intention and your client's intention. So I can only look at it at the fact that it is y'all's intention that he would have joint physical custody. So no, I find it reasonable that he fought for these years a shorter distance away and him still maintain joint physical custody. I find that very reasonable.
Your Honor, can I ask for one clarification?
Yes, sir.
I understand the court's order, and I appreciate the award on the $10,000 on the previous issue, but did the court consider on the current motion regarding interest and penalties, since there was no legal basis and we were the prevailing party on the court finding that there was no basis for interest or penalties, would the court consider awarding fees on that issue?
No, not at this point. I have seen quite a few other more seasoned people, or just as seasoned, less seasoned, more attorneys who have actually argued that point. And I'm not sure if there is a consistent ruling from the bench all across family court. So I am going to find no on attorney's fees because that was really just a small portion of what y'all did. The majority of this, I believe, was on the attorney's fees for 2-3 years of hard work by a bunch of very good attorneys.
Very good, Your Honor. I'll prepare the order.
I just want to be clear on your basis is that you think an order should have been entered from January the 25th of 18 hearing or a prior hearing?
There are two different orders that came down because it was in May. I believe Judge Steele actually ordered you in the courtroom, and that may be where I had it all mixed up, where you were also supposed to be preparing that order, clarifying what the situation was. And that order never happened. We've got two orders from this period of time that never took place that may have cleared up the child support because he did have an increase in child support at that time. But since that order was never entered, and even when it came to Judge Pomerantz, there was still it still could have been put forth. The child support could have been put there. But you were busy attempting to go in there and get above what the limits were, the statutory caps were on this.
No,
So,
Brianna, we're trying to maintain under the Rivero case the ruling from the order, the stipulated order from July 8th of 15 says that it just said residential parent, Caroline in the school year and other special holiday times that aren't awarded to Shane. And when we came to court, both Judge Steele and Judge Pomerantz said either there had to be a 20% change in his income, which they needed a hearing for, or there had, they wanted to count the time under Rivero, which would require a hearing. The only thing that held this up was that he wanted to get more time pending the litigation in order to actually meet the Rivero standard. And I think you're missing that point with respect, Your Honor. And I would request that you maybe take this under advisement and take a closer look at my notice of submission of proposed order. The defendant was supposed to prepare that order, and when he didn't, Judge Steele was going to issue an order to show cause. So we submitted it in the record, a notice of submission, and she struck it. It says, order striking supplemental exhibits. So I wrote the whole motion, which was not a frivolous motion, to clarify to the judge that she made an error, that this wasn't exhibits. It was a proposed order to get my client the $1,100 a month that was ordered. And that's where it went sideways, because you'll see the defendant argued it and he attached his order. So I really think your whole basis for even the $10,000 is in error based on those accurate procedural facts.
Ms. Vaccarino, during that period of time, how many times had you appeared before Judge Steele?
Before, you mean in this case?
In any case.
Oh, I had appeared before her prior, and she will issue an order to show cause if you don't timely submit an order. I did not submit any exhibits. I know she, even though you're allowed to as offers of proof, but there was a mistake, and it was by the court.
There was a lot of time wasted on attempting to, I looked through all of the letters that was provided to me because I wanted to see the basis on what sort of negotiations and everything going on. There was such demands at trying to get him to pay 18% of his gross monthly income without taking into consideration the caps. This was also a joint This was a joint physical at the time. So Wright v. Osborne did apply, and you were not even subtracting that from that total amount of money. Until custody is changed, those principles still apply. And that custody did not change until you all entered into your custody agreement just a couple of months ago. So no, I am not going to change my mind.
I just think you are erred in the facts leading up to why you're granting that $10,000, but as long as the record is clear. And our letters are in the record too. We never demanded above the cap. What we said was, at the time when she was making $100,000 a year and he was making $250,000, he would still be at the cap. We also said that he was not incurring those transportation expenses because he's a pilot, and all of those anticipated expenses, he wasn't doing all of his visitation, number one. And you didn't see that evidence because we settled at the end. And number two, he was not actually incurring those transportation costs, and Mom actually was incurring half of them, if you look at the July 8, 15. So, Your Honor, under Rivero, I think you're erring by saying this was always joint physical because it wasn't. It was a residential timeshare that didn't label it, and labels don't matter. The actual timeshare matters, Your Honor. So if you wanted to have a hearing to add up the days to see that this was frivolous on his part, and you'll see he's asking for 50 more days, 5 per month for 10 months. So I'm respectfully asking the court to maybe take this under advisement.
How many more days was your client asking to try to take even more time
All
away
she
from
asked
that?
for was about 3 to 5 more days in the summer and every other Christmas to have more time. When he refused, she withdrew that request long ago.
Yeah.
It would not have changed the timeshare. It was maybe a maximum of 7 days for the entire year, and you can see in the letters that she withdrew that request and said it's not worth it. But he clearly has.
I've already stated that when there is any ambiguity, it's going to go against the drafter, and since the drafter in this case was an attorney against a non-attorney, I'm not changing my mind on that. I'm sorry, I'm not going to do it. Attorneys, when they're working with proper person litigants, we need to be more careful and explain, and not necessarily giving legal advice, but we need to make sure that things are spelled out in plain English so it's understandable.
Well, Your Honor, that would violate the prospective client rule. He was not my client, and in fact, I was not allowed to explain things to him. It doesn't have to say primary or joint if the timeshare actually under Rivero dictates an actual timeshare.
Ms.
So I think that's where
there is ambiguity in that, and I am going to decide against the drafter. It is a contract principle. No, he was not your client, but you still had a duty to a fairness to the opposing party. I do not find it fair in playing a word game when you are the person who had more knowledge in this area than a proper person litigant. Any ambiguity is going to go against the drafter, and you were the drafter. Mr. Shapiro, will you please prepare the order?
Yes, Your Honor.
Thank you.
Thank you.
Thank you.